Well, we have a terrific discussion today. We're going to be covering the new Chinese privacy law, a huge development in the world, and one that's going to affect, I think, virtually every company out there. And this is part of our normal, our ordinary discussion series with Dan Solove and myself. And we're delighted to have Ed McNicholas from Ropes and Gray joining us today, along with Mingli Shi, another expert on the new Chinese privacy law. So great to see you both here today. And Dan, great to see you. And if you don't mind, Ed and Mingli, why don't we start by just having you all give a brief introduction on yourself, and I'll start off with questions. Mingli, do you mind starting us today?
Sure. Thank you for having me. Hello, everybody. I'm Mingli Shi, privacy attorney at Qualcomm now. My daily job is to make sure our practice is in compliance with global privacy laws, including China privacy law. In addition to that, I am also a frequent contributor to a think tank called DigiChina, which is affiliated to Stanford Cyber Policy Center, where I work with other US and global China tech policy experts to monitor and analyze the development of China data regulations and privacy law. That's it.
Mingli, it's great to have you on today. And before I turn it over to Ed, would you mind giving us just a few minutes on, how did you get into the privacy field? And, what was your background before you got in?
Sure. How did I get into this field? I should definitely thank Professor Daniel Solove. I did my law school in GW Law, and then I took his class. Undoubtedly, he is a fantastic top authority expert in this area, and his class was so fun and interesting, which triggered my interest in this area, and I started to pay more attention there. I started my internship, externship, and gradually landed where I am here to work on privacy law as a full-time job. Which is fantastic.
Well, that's terrific, Mingli, and not to make my co-host blush here today, but I don't know if you saw, there was a recent law review article published in the last few days that actually highlighted that Dan is the most oft cited. Now, they defined young scholar, so I'm not going to go into that to embarrass Dan. But
there was a footnote on that.
Cited young legal scholar in the country right now. So it's a pretty big. Obviously, it's a huge honor for Dan to see your colleagues citing your work like that. But it's also an indication of how much interest there is in the privacy field at this moment. So. Well, welcome, Mingli. It's terrific to have you here, and thank you for joining the conversation today.
Thank you for having me.
And Ed, great to see you. Ed McNicholas from Ropes and Gray. Ed, do you mind giving a little bit of background while Dan's rejoining us?
Sure. My name is Ed McNicholas. I am the U.S. leader of the data privacy and cybersecurity practice at Ropes and Gray. I'm based in Washington, D.C. Actually, just a few blocks away from GW Law School, where I'm an adjunct on cybersecurity law and policy. It's odd that I came to this area. I was started out as a litigator last century. Worked in the White House under President Clinton on there was an issue with an intern that came up and took some bandwidth. And came out, but that was not going to repeat in private practice. And so was happy to see that California passed a data breach notification law. And then someone made an allegation against a telecommunications carrier that they were providing information to the NSA, and wound up working on the NSA telecommunications record litigation for years, and kind of fell into privacy along those lines. It is this whole development of the Chinese privacy law has been fantastic. Having spent so much time on the US-EU dialogue, that'll be kind, sometimes it's not such a dialogue, between the Americans and the Europeans, to watch the Chinese privacy law come into the fore. Back in 2017, is actually at a conference that Dan organizes at GW. And I did a talk on the new cybersecurity law, and he introduced me to Mingli as one of his star students and said, you should do this presentation with her. She's really sharp. And then he noted, and she's actually a Chinese lawyer, unlike you, Ed. So she can actually read the stuff in Chinese in Mandarin, which probably is useful. And so it's been just amazing when you initially started having sessions about this in 2017, 2018, as these laws started rolling out, there was very little interest, only really among like defense contractors and some people who operate intensely globally. And now with PIPL, boy, has interest exploded.
Well, yeah, I mean, Ed, thanks for the background. Dan, welcome back. It's been a while since you and I were together. So while you were off for a few minutes, we got to sing your praises here a little bit, and the recent law review article by our good friend Woody, who cited you as the most cited young legal scholar. Now we'll tease you about that a little bit later, but anyway, just so we catch you up here, we got a chance to welcome Mingli and welcome Ed to the panel. And first of all, on behalf of Dan and I, thank you both for joining this discussion here today. Ed and Mingli, I do agree with you that this is likely to be one of those major issues that virtually every company has to start thinking about quickly. And it's gone into effect, or the way in which it's been adopted has been very fast if you compare it to sort of other global privacy laws. And so we're looking forward to the discussion today. And with that, maybe I'll turn it over to Dan to at least let you jump in here, Dan, and start us off on the discussion.
Great. Glad to be back here in the broadcast. Thanks so much for the kind words, especially calling me younger. And it's always nice to be young again. So a few things I would be really interested in your perspectives on this new law are first, some quick thoughts about how it compares to the GDPR, at least on the surface, on the text of the law, kind of what the law requires. But then drilling deeper, I'd be interested in your thoughts on the unwritten parts of the law that might diverge from the GDPR, because there's a lot that looks the same, but maybe in practice might not actually wind up being the same, depending on how the law is enforced and interpreted. So I'd be really interested to understand in context, is it as simple as just grafting all these GDPR-like provisions in China? Are they going to work the same? Are they going to look a little differently because of the fact they're in a very different environment?
Sure. Ed, do you want to say something here first?
Oh, sure. I'll jump in. To my mind, the comparison to the GDPR works on a superficial way. The language is similar, and at the end of the day, people will get privacy notices, and the use of personal data is restricted to certain purposes, and there are onward transfer provisions. And so it can fit within an existing global compliance framework, but on a not that much deeper level, this is a fundamentally different law. The EU is motivated fundamentally by protection of human rights. And I think China is fundamentally motivated by the assertion of sovereignty over the data within the country, that they want to control the information in the country and make sure that it is, and to put, I don't mean to, I think the sympathetic reading of that is that they want the state to control that as opposed to having private companies control that. They don't want American tech companies to control it. They don't want Chinese tech companies to control it. They want the will of the people, as embodied in the Chinese government, to control how data is used in China. And that comes from a much different spot. And so you're going to see that in terms of much more localization. Cybersecurity has a much different meaning in that it's all about protection of the state and its environment, fundamentally, from outside influences. And there will be significant incongruities between a normal global data protection program that's kind of based on the GDPR and what you'd have to do to comply with PIPL. A lot more localization.
Yeah, I totally agree. And I think China privacy law certainly adopts many GDPR elements, as Dan and Ed just mentioned. And also, as Ed just mentioned, I think the legislative and regulatory focus could be different from the approach in the European Union. For example, privacy is not deemed as a fundamental right in China. And definitely China privacy law and the whole data governance regime has this national security interest as its focused area. On the other side, I want to point out that China also has this national strategy to develop digital economy. China's digital industry is booming, and they basically digitalize everything there. And I think China government has clearly expressed its determination that they will continue to take a great effort to promote and invest in industries around data, big data, and AI. And I think that may also be reflected in the way the China privacy law is drafted. For example, China privacy law actually doesn't specifically mention the rights on personal information. So they say the protection of personal information, but they don't explicitly mention right. And the original word used in China privacy law, which literally is translated into interest and rights, but that Chinese phrase actually is more focused on the interest aspect rather than the rights part. So I think China privacy law and its whole data governance should be interpreted with this with this big backdrop in mind, which means they have focus on national interests, they have focus on cyber sovereignty and data sovereignty, and they also want to have certain flexibility to further release the potential powers that could be brought by the data.
Well, if I may just jump in for a moment, there's some really interesting points to unpack from both of you. And to me, this also gets to an interesting kind of theoretical / live issue on how, let's set aside China, if I may, because I don't want to just focus on a single country just for a moment. So let's go to the realm of the hypothetical and go back to our law school days. Imagine you're back Mingli and Dan's class, for example. Okay. Now, imagine you had a totally hypothetical, but really authoritarian regime. Again, nothing to do with any of the current countries. One interesting concept is, how could a really authoritarian hypothetical country use or weaponize some of the provisions in a privacy law for ill, right? Like if you set it aside from our current subject. And again, not on the current subject, but there's some very substantive areas in privacy law that can be expanded, if you think about it, for all kinds of purposes, right? Use restrictions, determining what is automated processing or not, the localization options that you have around data for when you declare it to be a, kind of a localized asset or something that the government can control on a totally country by country basis. It has interesting things that you can imagine go into law school exams in the future around how these can be used in kind of interesting ways. Now, if we shift back from that hypothetical example, Ed, I wanted to unpack some of your comments on, certain of the provisions and some of the motivations behind them in the Chinese law, in your view. as contrasted with some of the other countries that have adopted privacy laws. Do you mind expounding on that for a few minutes in your perspective?
Sure. I think that, when the GDPR came out, there were some people who are even the directive. People say, "Oh, this is a trade barrier. This is a non-tariff trade barrier," and over time, I think American scholarship has become more convinced that no, the Europeans are fundamentally concerned about the protection of the human right to data protection, and have kind of joined in that chorus. I think part of what's going on in the Chinese data protection regime is that there's a whole series of laws. For some reason, PIPL is the one that's burst onto the screen, but there was the 2017 cybersecurity law, the 2010 state secrets law. There's a biosecurity law. There's several of these things that all together assert what I think Chairman Shi has been very clear about, is the notion of data sovereignty, right? This notion that China wants to be in charge of the information in China. And this is, I don't think it's kind of, I call it like Middle Kingdom isolationism. I mean, certainly there's aspects of that in Chinese history at times. I think this is more about wanting to not treat the internet as a commons in which people can go out and grab pieces of information, but to say, we are going to self-consciously negotiate out who's in control of this. And that is a radical shift in the way the internet has developed so far, because the internet so far has been a commons in which big companies have asserted themselves and developed their presence on the internet. And China is saying, no, it should be the nation states that come together and negotiate out what's going on, not big tech companies. So it is a really substantial challenge to the order of how the internet has worked so far. But it's not, I don't think it's easy to I don't think it's authoritarian in its nature as much as it is about the assertion of China's place in the community of nations, and a desire to have it be negotiated out nation state to nation state, as opposed to nation to company.
That's a great point. Mingli, what's your reaction to that?
I agree. I think so. How about let's just talk a bit about data localization and cross-border data transfer restrictions. So for sure, China, China has quite a few laws imposing seemingly strict restrictions on cross-border data transfer, and they require certain data localization things. But that is also a growing trend in other parts of the world. But I agree that how the China government will enforce that regulations, and how the China government will actually interpret the currently broad legal requirements on data localization and cross-border transfer could make a big difference. So I think we should keep an eye on how China government would take approach. For example, China last week launched a draft rule about security review on cross-border transfer. So that rule lists several categories of data that must be subject to a security review if these data would be transferred abroad. But quite a few key terms in that draft rules are still very vague and broad. While we are waiting for the final regulations of that particular security review rules, I think there is still certain space and certain space to watch how and whether China regulators would really impose a very strict rules to limit data transfer, and whether they may actually consider to take certain flexibilities in light of their national strategy to develop a digital economy, as I just mentioned, which actually also need certain flexibility in cross-border data transfer and other policies around big data and AI and these kind of things.
Yeah, that's a good point. Over to you, Dan.
Yeah, one question I had is, there's a couple provisions in the law that diverge from the GDPR that I think could be pretty notable and more restrictive on data use and just generally you doing business in China. One is the requirement of the requirement that there has to be a PI handler to regulate in China, actually be in the company. So there has to be this representative for foreign data handlers. And then also there is no legitimate purposes, lawful basis to process data, which is, I think, the most common lawful basis used to process data under the GDPR. So I'm wondering how this is going to play out without that lawful basis, and also with this requirement, how broadly this is going to apply for every business doing business in China. Do they actually have to have a person in China? What does that mean?
Yeah, I think so. The law is quite clear on that foreign organizations that would be subject to China privacy law, then they need to establish a local office or appoint a local data protection staff based in China. And then how the law would handle the lawful basis for data processing relying on legitimate interest. I agree that the current China privacy law does not specifically mention legitimate interest, but interestingly, there is a provision under that lawful basis article saying that other China regulations may provide additional permission for data processing. As I mentioned, the China law tended to be drafted in a broad and a vague way, which is to leave flexibility to the future implementing rules and enforcement activities. So when I put all these information together, I think it's still possible that in the future, maybe China would issue another implementing rules or regulations saying something equivalent to legitimate interest as the lawful basis for data processing. Yeah, I personally still a little bit optimistic on that side, but I agree based on the current law and looking at our current practice, we probably have less flexibility compared to GDPR when we process personal data that's subject to China privacy law. And we tend to rely on consent and maybe a few other quite restrictive approach.
And it's interesting how in approaching this, I tend to default to this comparison between Chinese administrative procedure and US administrative procedure, as if China has an Administrative Procedures Act and the court doctrines of deference and all this, and but China doesn't have Chevron deference. And I encourage people to read the 2017 cybersecurity law. It's rather short, and as an American lawyer, the first time you read it, you'll probably start flipping through it because you're thinking you're reading the preamble. It's written so broadly that you think, well, this must be the stuff at the beginning, and I'll get to the real substance provisions, and you get to the end, and no, it's all preamble. It's this broad articulation of norms, and then things are defined further and further down, and sometimes significantly there are changes and material moves in the regulation as it expands. So I'm not overly worried that legitimate interest isn't expressly articulated in PIPL. I think in practice, there's going to be a large degree of margin for maneuver that companies will have there. But it's a mistake to try to read a Chinese statute as if it's an American statute or an European statute. It's a different system of administrative law altogether.
Well, if I may on that point, Ed, so obviously part of the reason that this law would have received a lot of focus, a lot of attention under any circumstances. It's a broad law to be enforced by the Chinese government at a moment of, a lot of interactivity around the world on global data. But obviously, everybody's also been paying attention to the Chinese government's move to block the IPO of Didi that appeared to have been based in part on the amount of data that Didi held on Chinese persons and what going public in the US would do to what some perceive as a strategic amount of data in the possession of Didi. So it's kind of enforced this concept, Ed, to your point, and Mingli, to what you've been talking about, that the Chinese law obviously has a lot of protective provisions that in some ways mirror the fundamental structure of other international privacy laws. But if part of the motivation of the Chinese privacy law is trying to make sure that there's a strategic ability to govern, from this strategic asset of data, you can imagine it being used in a different way in enforcement proceedings. And it looks like the enforcer in China is the same entity that has the ability to, for example, take actions like with Didi. So my question is, first of all, do you have any reaction to that? And second, Mingli or Ed, could you talk a little bit from a practical perspective about the regulator here in China and what you can share about your perspectives of the entity that will actually be enforcing this new Chinese law?
I can jump in with a few quick thoughts. I agree what you just said, but I also would like to point out that I think it's also worth noting that China government still understands that in order to efficiently develop its digital economy and related industries that rely on data, they still believe consumer trust is a key. And they still believe regulation is a critical way to boost that trust. So that's why we've been seeing China is taking rapid actions on legislation and also enforcement actions recently on personal data protection. They seeking to more regulate this area and so they can mitigate the public concerns on data abuse, and then they can gain public trust. So that's the first point I'd like to mention. And for the Didi case, I heard there are also some behind-the-scenes stories around that case, right? It's not just about personal data and privacy. There might be some other factors playing around. But back to the privacy side, Didi case showed the China government again. They think data security is a critical part of national security, and they have concerns that Didi by seeking listing abroad these kind of data maybe not just personal data, but other data beyond personal data, which could be deemed as a part of assets that's critical to China's national interest. And China governments have that concerns that Didi may be willing to put aside the national interest by dodging the requirement to do data security before they can transferring the data abroad. So Didi case, I think it's a combination showing that China government's determination focus on national interest again. Yes, that's my 2 cents here.
Yeah. I think you're absolutely right, Justin. To look at this, look at the DD case and look at this law as part of a comprehensive Chinese data industrial policy. They see, and I think everyone does, data is the new oil. It is a great future industry, and they will have an industrial policy for tech companies the same way they have an industrial policy for other segments of their economy. I think people maybe before she were concerned about, or maybe celebrating that China was becoming too capitalist, and it's like, no, one thing is very clear across the Chinese government. It is socialism, and not the kind of socialism we talk about in American politics, real socialism with industrial policy that is using the sovereign interest to control corporate activity. And so I think that we will see more things like the DD case coming forward.
Well, I mean, I'd have a question, but Dan, I want to give you a chance if you want to jump in.
If you have a follow-up to this, feel free to go ahead.
Well, I mean, one of the main practical items that's coming up a lot right now is how do you, if you're in a position where you have data on Chinese persons, okay, how do you, either of you have thoughts on how companies outside of China should start thinking about what are your obligations if you happen to have data on Chinese persons that you have either obtained somehow from a source in China or that you obtained from a third-party source? And what are the practical consequences that a company should be thinking about right now? And of course, I asked this question because you know that the provisions on their face in the Chinese law around extraterritorial application of the law based on transfer of data about Chinese persons is drafted, in my view, in a quite broad way, in a very sort of it on its face would purport to include quite a few companies who have data on Chinese persons. So do you mind if I start with that? Do either of you have a reaction to what do you do if you either are receiving or holding data on Chinese persons, and what are the practical things you should be thinking about right now?
Okay, I can go first. So first of all, I think the extraterritorial application of privacy law is not, again, it's not unique to China, right? Like GDPR also has similar requirements for foreign organizations that collect personal data of EU residents. So similarly, China privacy law also adopted this approach that if a foreign organizations process personal data of people in China, or they assess the behaviors of people in China, then they are subject to China privacy law. Also, I'd like to point out that China privacy law still focus on the data activities within China. So that is also related to China's approach on cyber sovereignty and data sovereignty, because they want to exert that regulation for the things happening within their territory. That is the first point I like to point out. And the second one is regarding compliance suggestion. I think while China privacy law seems to share many GDPR elements, but evils in the details, so compliance with GDPR does not necessarily mean you will be good with China privacy law. For example, China privacy law still heavily rely on notice and consent, and there are a few additional compliance obligations, like you need to do regular auditing, and you need to do data categorization, and if you do cross-border data transfer, you need to pay attention whether your data will be subject to data localization requirement by default, and you may want to design a flexible data governance plan for your data generated in China, just in case that you may be subject to that data localization requirement, not just on personal data, but potentially also on non-personal data, for example, important data, which is another concept on the China data governance region that requires data localization. And then if you are a big platform, for example, you run a big social media service, or you run an app store, then you are subject to additional liabilities under China privacy law. Like you need to have an independent supervisory body composed of external experts to supervise your data activities, and you need to set up a platform rules to regulate these service providers on your platforms. And then you need to regularly publish a responsibility report regarding how you protect the personal data. And yeah, I think that's what I can think of at this moment. Do you have any additional thoughts?
Sure, I just think it's going to be important to have a awareness of the potential application of long-arm jurisdiction. If you have a few employees in China or an office in China, then you think, well, can we just localize that data? Do we really need to export it? Maybe there's a lot of data export that just happens because it's easier for companies. And that sort of thoughtless data export, you should reconsider. The other piece of it is, if in fact you do need to have a unified global system, it will be vital to watch how this international data transfer system plays out over time. I think that we've gotten used to talking about standard contractual clauses as something a legal assistant can slap on the back of an EU contract. And then we're fine and we just roll ahead with the data transfer. I think that the Chinese contractual mechanisms for transfer might be more onerous and might require a bit more consideration of whether or not it's going to be viable to transfer some sort of data out of China. And there will be a default to keeping more data in China. So there'll have to be, I think, on a practical step, first an inventory of what data you have in China, how you're exporting it, how it's being used, and whether or not you can reconfigure that to be more compliant with this new regime. This regime is not. This is just PIPL's one piece of the regime, and I think this regime will just become more focused on localization over the long run.
And the only other point I'd make is, in my view, just on the reading of it, but again, Mingli, maybe you or Ed have a different from a practical perspective, because there's some provisions that mirror each other on extraterritorial application, but there's slight nuanced, one could call them slight, but slight turns on the review processes before you can transfer data overseas. For example, if there's a strategic or security element to it, first of all, it has a chilling effect on transferring data overseas by virtue of the way it works practically under GDPR and other regimes. And obviously, there's also a concept of blocking the transfer that doesn't, quite happen as a practical matter under other regimes. So my read of it is maybe the law is roughly mirrored, but it looks like the Chinese law could have a much more broad practical application of the extraterritorial transfer application, or extraterritorial application just by virtue of the way China may enforce it. That's my perception. But anyway, I want to turn it over to Anne for a moment to jump in.
I guess as a practical matter, what should companies do now? Because it definitely, as you both explained, a lot of what Chinese privacy law involves are the standards that are enacted, really matter and make some very significant substance in those standards that add to the law and even change the laws. But for now, the law went into effect very, very quickly. One of the shortest periods between enactment and going effective that I've seen in most laws. Usually you get a year or 2 years. It's a matter of months, and now it's effective right now. So a company that does business in China, what should they do? In particular, like how does this change what they might be doing already? What would be your advice for, things that, like a quick checklist of the most important things that should be done?
Okay, I can start with a few quick thoughts again. I would like to say, so as I just mentioned, data inventory and data mapping, I think that's particularly important for data activities in China, because in addition to these privacy law requirements, China also imposed quite strict data security requirements through its privacy law and a few other related laws like the data security law. And these data security requirements require data handlers to grade the data and also to categorize data. So currently China law does not specifically say what you need to do after you classify your data and put your data into different categorizations, but I expect there would be follow-up implementing rules that will impose different levels of security requirements depending on how you classify and how you categorize your data. So my advice would be to map your data, to do this data classification and categorization, to get prepared for the implementing rules that I expect will come out very soon, that will impose different levels of security requirements on these different data things. And also that's also related to how you decide whether you need to locally store certain data, while you have more flexibility for certain data for the outbound data transfer. So these are my currently 2 cents thoughts here.
I think in terms of running a privacy program, I don't know that a well-run Chinese program is going to be all that different than a well-run European program. It's going to be knowing what data you have, how it's being used, and then putting appropriate restrictions on it. And those restrictions might be more focused on localization. In Europe, you can almost always sort it out to the transfer gets to go forward. Here, the transfer might not get to go forward, but that's fine as long as you're aware of that up front. And I think that some of the uses of information might be particularly worthy of attention. I would make sure that I knew how my organization is using data in China for marketing purposes, and also integrating that data into any big data or analytics platforms, so that we can understand whether we can continue to integrate that data or whether we need to have a different platform for China and a different platform for outside of China in terms of various engines. But I think that we're going to see essentially the same kind of data governance take root on a corporate level in China as we do in Europe. It's just that the laws are, as we said, they come from a different place and have different goals.
Yeah, I mean, in some ways, Ed, if you're a company that's been doing business internationally and you haven't been thinking about a privacy program, then you probably have bigger issues. If you have, and you've been implementing the sort of basic elements of a privacy program, you could use Privacy Shield, the framework, as a model. You could use GDPR. You could use the combined California laws. They all fundamentally have the same rough structure. And so although there's nuances, but if you're implementing that way, you're probably setting yourself up for roughly a compliance path with the new Chinese law, just like you would be setting yourself up to comply with GDPR and California, for example. That said, there are some very important nuances, and I'd say I'd really highlight transfers out of China as a big area. This is my personal reading, as a big area that you should really pay attention to, especially if you're working at a company that has enough personal data of Chinese nationals or Chinese persons that it might be perceived as a strategic item, or something that may trip into another kind of concern by the Chinese government. I'm sure there are other provisions, but to me, there's a rough parallelism to it on my read, but there's a lot of consequences you could have if you don't, pay attention, especially to the extraterritorial transfer nature of the law. And that's one of the provisions I'd recommend companies pay a lot of attention to. Any reaction to that?
I think it's absolutely spot on. And that assertion, if it's, I know this has appeared kind of on the stage, even though it was a draft last October, it appeared rapidly. But if you look at it in part of the overall Chinese data legal regime, this is not all that surprising. This frog has been on simmer for quite some time, and it is getting pretty well done at this point.
Yeah, and just a very quick add-on. So as I mentioned, it's not just certain personal data that could be subject to data localization requirements. There are also additional types of data, including important data, and also the data generated by critical information infrastructure operators doing business in China. And these key terms have not been clearly defined by China law yet. So paying close attention to the development of China regulations is another suggestion I would give for compliance with China data governance regime.
That's always good advice. Pay attention to the regulators. That works in any country.
Well, look, those are really terrific practical observations from both of you. I think this is a new law, but it's one that affects a lot of companies. Obviously, not only getting on top of the major requirements quickly, but I bet there will be a full employment act going on around implementation. I think Mingli and Ed, in terms of getting a person responsible, for your privacy program in China or accountable in China, it's got to be a big challenge for companies that have data on Chinese persons because of some of the provisions that surround that. And Mingli and Ed, I suspect you both are going to be very busy here, along with the entire industry, helping companies try and get on top of this. Obviously, we too, we're focused from the tech perspective on helping companies get compliant. Our WireWheel team is, but there's a lot of human capital that's going to go into this, I suspect, and in ensuring that you have a responsible person and who's accountable, for the compliance from the Chinese government side, together with making sure that you have the controls in place around some of the most important provisions, although they're all important, but most important provisions. And from my perspective, transfer of the data out of China and use of the data outside of China is probably among the highest priorities to look at if you're looking at this issue.
One of the things that Mingli's pointed out over time is there are some great resources on translation. Mingli's smart enough that she can read the Chinese directly, but I have to wait for the translation. And so I don't know if you want to, Mingli, if you could give some of the sites you use for where these laws in translation exist, because keeping up on this, I had a hard time learning Mandarin at this point in my life. So I'll have to wait for you to translate. But where should I look to find good translations?
Sure. I think there are quite a few organizations or websites dedicated to translating China laws and regulations, including DigiChina that I just mentioned. If you just Google search DigiChina, and that should pop up. So DigiChina focus on translating of regulations relating to China digital policy. And there are also a few other Chinese law translating website, but I forgot the name. I can provide later if people here are interested. But if you just Google search China law translation, I think there should be some there. But I personally feel a bigger headache is from China's national standards in this area. So China has a organization called TC260, which is equivalent to the NIST in the United States. So TC260 issued hundreds of national standards every year, and I think most of these standards are very lengthy and very detailed, and unfortunately I haven't seen many organizations dedicated to translate these lengthy national standards. So maybe the best solution is to hire someone who can read and speak Chinese.
Well, Mingli, if you wouldn't mind, share the links, if you wouldn't mind, with our team. We'll make sure to post them so that folks can at least see them.
Okay.
WireWheel hosts a regular event called Spokes, and I know you attended and others do. We have another one coming up on December 7th and 8th. It's a free and open event, and obviously I hope folks can join us at the WireWheel Spokes session. But we're going to have another session that's talking about the Chinese law in practical terms. And certainly we can share that there. And I hope you all will participate in that as well, because there's a lot of development going on right now in this area that needs more attention. And, in that regard, let me just say we're hitting the hour mark. From my perspective, this has been an absolutely fantastic session, Ed and Mingli. Dan, I'll let you give the closing remark, but from my perspective, I really hope you'll come back and join us to talk about the law and how enforcement proceedings go. From the WireWheel team, please come join us at Spokes on December 7th and 8th to continue the discussion on the Chinese law. And it's been really, really informative from my view. Dan, over to you.
Well, thank you both so much for joining us and for your insights. I've gone to both of you for so much insight into the privacy and security law of China, and you both are really go-to folks for that. It's particularly helpful, especially with Mingli being able to offer such great context about how the specifics of Chinese law and the way that things are regulated in China inform the text of the law. And one thing I think that's really interesting that we're seeing worldwide now is this adoption of a lot of the language and a lot of the same concepts that we see in the GDPR. In the case of the UK, the GDPR practically verbatim. And yet, I think we're going to see over time how, even though a lot of the things look the same, in practice, they might not ultimately be the same and might diverge as they are enforced and as regulations come out. So I really think this will take some following over time to fully understand how the law evolves, because just looking at the language and reading the law is not enough. There's so much more there that we really will have to figure out as we see this unfold over the next few years. So I hope to continue this conversation and keep coming back to you both for further insights into what this law means and how this law ultimately will shape out, because I think the look of it, the feel of it will will be very different and will evolve over the next few years.
Thank you.
Thank you. Thank you for that.
Totally agree.
Yeah.
Totally agree. Well, thank you both. Look forward to seeing you soon on another one of our sessions.
Thank you. Bye.
Thank you all.
Thank you. Bye.